Good afternoon. Thank you for joining us today for a very important presentation. And you see a little bit about me. I've been doing equal employment opportunity matters for both federal sector and private sector for several years, more than 33 years of experience in the area. It's an area that is very unique, and it gives an opportunity to be very helpful to others and to those particularly in need at a given time. So I've handled these matters at administrative levels, in the courts, and even before the courts of appeals in this jurisdiction. So happy to talk with you today about this. Next slide. This is just an outline of what you're going to learn today. You'll learn when and how to file your formal EEO complaint, the timelines to understand during the formal complaint process, and it's a very important period for you in presenting your claim. You'll learn the investigation phase of your formal complaint and what that entails. Understanding the report of investigation, which is the actual compilation that you'll get from the investigator who conducts the investigation in your case. And also you will learn about what choices you have upon receiving that report of investigation. Next slide. So now you're transitioning. So at this stage, which is the formal stage, you have actually gone through what we call the informal process. That means you filed your EEO complaint, you've actually met with a counselor, you've discussed why you have come forward, what you are complaining about, and an ADR attempt, which is an alternative dispute resolution ADR attempt, was unsuccessful. And what that means is that you were not able to receive or obtain a resolution that you were willing to accept. So now your case has progressed to the formal stage. You'll receive a notice of right to file your formal complaint from that EEO counselor. Pay particular attention to that, because when you receive that notice, that date is very important. When that date comes, you have to have that formal complaint presented. You'll get the forms and what it is that you have to fill out. Just make sure you're very vigilant about getting that in and getting it in timely. And when you're doing that, things you want to consider is, do I need at this point some formal guidance, an attorney who will help me actually navigate what's about to come up? This process can be very confusing. It can be very particular in terms of what's being asked for, and also finding out what you are holding amongst all of the documentation that you have that may be particularly relevant or important in trying to prove your case. So consider getting an attorney involved, and there are certain times that you'll have to get this formal complaint in. It's 15 days, and there's a lot that you need to do in that period. So begin to work on it as soon as you are notified of that. And your timeline of what happened to you, how it happened, and all the people involved will become so critical all through this process. So do work on that as well. And that story is already out there because you've talked to the counselor about it, but you want to start defining specific timelines, learning and adding in information as it comes to you. So I recommend that you put something up on your computer or in your notes and just go back as things come to you, as you recall things, and embellish it to add to it. And that's going to help you greatly through this process. Next slide. So now you're going to file the formal complaint. Once again, you're going to do that within that 15-day period. You'll do it using the forms that you have received from the EEO counselor when you are notified about this. Now, one of the things that I run into as counsel, and when I'm looking and talking to people about the formal stage, is I get the story and I will get information pertaining to what they would like to file about. But I do something called a back check. And what I do is I ask them to share with me what they talked to the counselor about. And oftentimes you'll find that by the time you finish the informal stage and you're approaching the formal stage, there are more things you want to talk about. But there are implications there. There are things you have to be aware of. And so what that means is, unless you are amending your complaint, you are only going to include claims in the formal complaint process, the things that you shared during that informal complaint process. I'm going to pause there because that's critically important. And I know that we're talking about getting an attorney at the formal stage, but I will also put a stamp and say, And once you decide that you want to enter this EEO process, it's a good idea to get an attorney involved. And this right here that I'm about to tell you is a prime example. I just told you that when you start your formal complaint process, unless you are amending, you may only include claims that were part of the informal complaint process. So let's say there are hands up now in the room and they're saying, well, what if I thought about these things afterwards? Well, that happens. Here's the important thing. If you've thought about them afterwards, but you did not share them with the EEO counselor, there may be a problem trying to add them to your formal complaint. The formal complaint is comprised of those things that you've previously reviewed with the EEO counselor. So having an attorney early in the process will help you know during that informal stage whether things have happened or are happening that you may need to add to your discussion with the counselor so that it can become part of your formal case. Now, if you have something that has occurred after the fact, we're going to talk about this, a little more, but you have that time period of 45 days, which is a part of your informal case, to get your case before a counselor. You still have that time if you are amending in the event you've not talked with a counselor about these specific facts. You really want to be vigilant about that 45-day period that you have to bring the complaint, unless it gets the opportunity to join this formal complaint. So you are going to be including, as our third bullet points out here, what actually happened and why it happened. And I emphasize that because it's sometimes very easy because you've lived it. You've breathed it. You know it in your sleep, regrettably, what has happened to you. But you also have to spend a considerable amount of time answering the question of why it happened. So here it comes. You're in a meeting, you're before the counselor, and the counselor says, okay, you've given me 20 things here that you've experienced. This is what happened to you. Well, tell me why you think it happened. At that moment, you have to remember you have filed an EEO complaint. So what does that mean? You obviously believe that what happened to you was, first of all, illegal and discriminatory. So when you're answering that why it happened, pay particular attention to what you say next. What you don't want to hear coming from you is, I don't know. Because then the question could be, well, why are you in the EEO office? You ought to know because it looks like you think it's discrimination. So when you say that, we know you don't really mean, I don't know. What you mean is, I don't know why my supervisor is treating me this way because I'm a woman, or because I'm Black, or because I'm Hispanic, or Asian, or what have you. What you really mean is that, but you don't want to say, I don't know. So when you're asking, why did something happen? Take a moment and think about what really caused you to take those steps to go to an EEO office, to contact an attorney. And the answer will usually reveal itself. So most often than not, what ultimately happens is the person say, well, I feel that what's happening to me isn't happening to my colleagues. And it seems to be clear to me that I'm being targeted and treated differently. And then as you explore that, you'll see what starts to come out. Well, I think why it's happening is because my supervisor has a problem, working with someone who has a disability. He or she knows about my disability. They keep excluding me based upon that. And that's really why I feel this happened. So be very careful to make a very detailed list as to the whys as well, okay? Now, the agency on that fourth bullet there sends a letter acknowledging receipt of the complaint and tells you whether they've decided to accept all or dismiss some or part of your claim or your complaint. Again, you're paying particular attention here because you've now completed that formal complaint form, you've turned it in timely, and now you're getting a response from the agency. And that is called an acceptance letter, a partial acceptance letter, or notice of dismissal is likely those things you'll get, either of those things. So let's say you get a notice that says that we are accepting your claims and we have identified them as follows. And let's say there are 5 bullet points there. You need to read that. You need to read it very carefully because each point is asserting what they've concluded, the agency has concluded you were asserting in that formal complaint form that you submitted. So in the formal complaint form, you've told your story. Now, someone within the agency has read that, and from that, they've determined that you're essentially making 5 points, and they'll set those points out in those bullets. Read that carefully, because if what is stated in the first bullet is somewhat right, but doesn't really fully capture it, the real question is the essence of what I'm trying to complain about there? If you're complaining about a non-selection, does it say that? If you're complaining that you were denied the right to have training or attend a conference or to have leave, make sure it's saying what you intended. Because the importance of that notice is saying, here's what we see your claims to be, and it typically will tell you that you have 5 days to inform the agency as to whether or not they have accurately and correctly captured what you were trying to say in your formal complaint. And if you do not respond and correct anything within the 5 days, arguably it's now set. These will be the things that everyone will talk about going forward as to your claims. So take time, read that, respond within the timeline, and make sure that you understand and that the agency understands what you're trying to say. Perfect example is I had a client who actually didn't get the opportunity to serve in a position. She represented herself at the informal and the formal level, and I got involved after the case went to another stage we'll talk about later called the hearing request. So when I read her file and talked with her, it was clear to me that there had never been a selection. So I was confused as to why she had said I was not selected for this position in her accepted issue. And it became very clear to me what she was trying to say is that she was not considered for the position. Somebody else was just simply placed in that position, and it was not competitively offered as it should have been. That's not what her accepted issue said. And as expected, at that initial conference before the judge, the first thing the judge said is, Ms. Rucker, why are we here? If I understand correctly, there was never a position advertised for which your client was non-selected. So what's going on? And I had looked through the report of investigation, and I saw where she had actually tried to say that in a couple of places. So I quickly pointed the judge to that and said, well, she was unrepresented, but here she says right here, and I think it was unfair that I was not even considered to be a person to fill this slot, and you just put this individual in. The judge agreed and said, well, I think it's true. This was something she said. It was the agency's responsibility to help her capture that. I will allow a friendly amendment to this to represent that it's not a non-selection, but a failure to be considered. So you see what happens down the road if we're not doing everything just as we should in the beginning stages. So pay particular attention to that. And on this page, the last thing I'll point out is you may get something where it says you have claims A through J, but we're dismissing A through A through L. And so you say, wait a minute. I'm sorry, not L, but if you're saying I'm going to dismiss A through E and leave you with everything through K, do you have the ability to fight at that moment and say, well, no, I want all of my claims to go forward? Answer is no. You get to deal with that at a later stage when you go before an administrative law judge who will then ask you, were there any claims dismissed? And then you will be afforded the opportunity to say, yes, when I first started this process, I had claims A through E thrown out, and I think it was improperly done. But what's most important is you don't get to fight that at this stage. When you get that notice saying A through E is gone, it's gone, investigator will come out, only deal with the remaining claims, but you can revisit it later, and we'll get into that. Next slide. So now we're at the investigative stage. You'll get a notice from the agency at some point identifying the investigator who's been assigned to your case. And that investigator is an outside individual with no stake in the game, so to speak, who's been assigned to come in investigate your claim, and prepare a report, which you'll see in the third bullet is identified as a report of investigation. So that investigator is going to be interviewing you about what? The accepted issues. Those claims, those 5 claims you got the notice about. And that's going to be the investigator's script. They will not allow you to have them talk about things that are not listed there. So once again, another example as to why you have to make sure those claims accurately reflect what you're trying to talk about and what you're complaining about. You have the ability to give that investigator witnesses, documentation, but do understand that the investigator has the ability to say, I'm not going to talk to 7 people, I'll pick amongst them. And you really can't press that issue. You can't make the investigator talk to the 7 people you want, but you will again have an opportunity to address that later. So if there's a denial of a particular witness or a document, you do want to take the opportunity to address that in writing to the investigator so that it's included in your report of investigation that you only have taken 3 of my 7 witnesses, and also you didn't take some of the documentation. I see I gave it to you, but it didn't make it in. I have a problem with that. Could you please add that back? So make a record, because I've seen judges down the road ask when you start trying to bring in other documents and other witnesses, they will often ask, well, did you raise that with the investigator when they were investigating? So you really want to be able to say, yes, I did. And if you have an email or some other form of proof that you did that, that's going to bode well for you. The second bullet is sometimes very much a surprise to people. And it says what it says. The investigator does not decide merits. So often I'm asked, so you mean I'm going to go through this process? The investigator will interview me. And by interview, we're talking about ask you pointed and specific questions, really based upon what the law requires you to prove based on a particular basis that you may have accepted. So when you're going forward, as you did in that informal case, you told the counselor, this is happening to me. You've either picked your race, your sex, your age, your national origin. You may have said religion, disability, or retaliation. So now this investigator is going to interview you and ask you questions to reveal whether you have evidence to show what is required for any of those particular bases. So if you're claiming that it's gender, your questions will be, tell me why you feel your gender was a factor. Tell me who's of a different gender was treated more favorably than you, when, where, and so forth. So the investigator's questions will really be based upon what boxes you checked as to your bases. And then questions will come forward specifically surrounding that and any other relevant facts. But the investigator, after talking to you, talking to witnesses, including what we call responsible management officials. We use the acronym RMOs. After talking to those individuals, the record is created. And it's a compilation of the documents that the investigator will ask for based on your claims. It's a compilation of what you may give, what the agency officials and any responsible management official wants to give to be part of this record. And it will include witness statements. You then get that, but the investigator compiles it. He or she will not make a decision. In other words, there's no review of all of that and an ultimate decision to be contained there that says, I find that there's sufficient evidence or probable cause that discrimination occurred or did not occur. And so oftentimes people are like, well, then what is it all for? Well, it has its purpose towards the end, that record. But no, a decision isn't going to be made at this particular point. But I do pause to say that you're in the formal stage because settlement failed, but you always have the ability to revisit that, even throughout this process with the investigator. So definitely take advantage of that if you have the opportunity or you want to do so, even as you're moving through this formal stage. That investigator prepares what's called a report of investigation, and that's the ROI. And depending on how many witnesses, how many documents, that could become very voluminous. I've had in cases where it's volume 1 and 2 and 3. And just the other day in my office, one of the associates here in our DC office indicated that there was a case with the VA where there were 10 volumes. It's a lot of paperwork, a lot of information, but that's how it's done. Everything gets compiled in a report of investigation, and for the whole process to come to a conclusion, the agency is given 180 days from the date you file your formal complaint. And sometimes there may be a request to extend that, and you can get into doing that, and it'll give you some additional time. But you're going to have, from the point of the formal complaint to the ROI coming forward, a 180-day period. And if it's not done within that time, then you have certain rights that you are available to you where you can move your case forward notwithstanding. Next slide. So now you've gone through the interview. The investigator has asked you these important questions about what happened to you and why. And I want to point out as well that when the investigator is asking you why, if you pick multiple bases, you're going to be asked multiple times that same question. So you may get a question, tell me why this particular thing happened to you because of your race. And then you'll see, and that'll be explored in detail. Who are the comparators? What else do you have? Why do you say it's race? What did your management officials say? And that'll get explored. And then it'll come right back with, well, tell me why this particular event happened because of your age. And then you go through that all over again. So some questionnaires, some questions from investigators, an investigator could be 200 questions. And so it really depends on how many things you claim and how many bases you select. So now you have a right after you get your report of investigation, and it'll be contained in there, what's called your appeal rights, to go to the Equal Employment Opportunity Commission. So that's choosing an EEOC hearing or a final agency decision, often referred to as a FAD. Now, once you decide what you want to do next, you then pick, and you have a 30-day period after receiving that report of investigation to do this. If you select an EEOC hearing, what you're basically saying is, I'd like this matter to be reviewed by an administrative judge. So once you submit your paperwork in that 30-day period, the Equal Employment Opportunity Commission will at some point respond, identifying and indicating what administrative judge has been assigned to handle the case. Now, this involves litigation similar to what happens in federal court. It's at the administrative level, but you have a judge involved and you have other things that are involved in court, like affords you the opportunity for discovery. Now, discovery is an important tool, especially after you've read that report of investigation, because sometimes for the first time, you're learning about management's position and the agency's position regarding specific claims. Now you have the opportunity, if you are in this process, to ask for discovery, to get certain things that you normally would not have access to because those records are just not open to you. So you can do that through asking interrogatories, requests for documents, or even asking the agency to admit specific things, like admit I was certified, admit that I had more experience than the person selected for the job, admit that I made multiple requests to obtain training, and so forth. These things are designed to help you hone in and focus the judge on the wrong that was done and the fact that you were treated unfairly. Now, in the hearing request stage before the EEOC, the agency has attorneys on staff who will likely represent the agency during this process. It's also a very good idea at this point for you to have an attorney. This part gets very, very detailed. You lose major opportunities here if you're not using this process effectively, because ultimately the burden is on you. And so if that report of investigation, which goes over to the judge after you make a hearing request, the judge has provided that record by the agency. But if that record alone is not going to help you, you do need that discovery. You do need to know what you should ask for to meet the legal standard for the bases that you've selected. And navigating that could be very difficult sometimes for lawyers, much less for someone who is close to the case and not an attorney. So you really want to consider in this stage, with this process, getting an attorney involved and helping you gather the evidence that could potentially show that you were a victim of discrimination. Now, the administrative judge will conduct a hearing and make a decision. In this stage, you are going to get someone who says, based on the evidence of record, I believe there is evidence to show that discrimination likely occurred or that it did not occur, okay? And the problem is that the judge is going to rely on what you bring forward to meet the burden that you have. So they're not there, the judges are not there to help you with the case, but to look at the evidence that you present. Agency, once the judge makes a decision, let's say the decision is favorable to the agency. So the judge decides, I've looked at this record and the evidence you have, and we've had a hearing and I've heard witnesses. I do not find that discrimination occurred. The last bullet there is telling you that the agency has 40 days to implement the judge's decision. And then that will come by way of notification to you, and that will have your particular appeal rights, that notification. Next slide. So I mentioned discovery, and we do need to sort of dedicate specifically what that means. You're going to basically be able to obtain things from the agency that you didn't know that you may need to request until you read something that a particular manager said, or you wanted to know, or you believe that your performance evaluation on a similar critical area was judged differently than your colleague. Well, now you get to ask for your colleague's performance evaluation to see. Most times we don't know the answer to the things that ail us the most, and that is why discovery is helpful. But I do want to put a pin there to say it's not a fishing expedition. You cannot file these cases simply to ask, I think something's happening, let me get some discovery and I'll know. That's not how it works. You have to have a good faith belief, and then you can get access to those records and those other things that may help you prove that. The agency is also going to come and ask you questions about your case, to ask you to answer certain interrogatory questions, as we call them, to produce certain documents, or even to admit to certain things. Just understand that when you're serving the agency the discovery, which has to be responded to typically within 30 days of when it's served, and the judge at that initial hearing, when you're in the EEOC stage, determines how much discovery, if any, is granted, when you have to initiate that discovery. That's critically important, because typically these judges will ask, at the EEOC level, will ask that you initiate any request for discovery within 20 days of the initial conference that's held. And oftentimes people come to me well after that. And I'll ask them, well, did you serve discovery? And they'll say, no, but I got this from the agency. My heart sinks, because now I know the agency has gotten discovery where you have to answer, but you may have missed your opportunity to ask the agency questions because that judge said initiate within 20 days. And when I do the math, we're inside of 30 or 40 days. That's not a good thing. So that becomes another factor and reason why getting an attorney is critically important to navigate this process. So once you are served discovery, you typically have that time period to answer. There are consequences if you fail to answer, or if you answer the questions not completely. The agency can move to compel you, and that could bring also sanctions such as decisions against you. Certain inferences or questions or points that you are raising could be decided against you simply by not complying with the judge's order or not answering the discovery as you should. And I see that sometimes hurt a lot of people, because sometimes you'll have a case, but you haven't gathered the evidence yet, and it's out there. So let's walk through each step as we should, get people involved who can help you, and get the evidence that's out there to support your case. And the EEOC basically will assist people whenever they're asking for more time. We can do that as counsel through motions. The judges sometimes will work with us, but that schedule that the judge set, I'm finding, is very strictly adhered to except for extraordinary circumstances. So just remember that. Next slide. So at this point, the judge has assigned what we call a number to your case. So there are certain things that you have to do when you're responding. You're putting that number on everything that you're filing so that they can identify the case. Also, you can't communicate with the judge directly. Even if you're not represented by counsel, you can't just simply call the judge, have a conversation, or send a letter. That's called ex parte communication, and that is not acceptable. You have to always have opposing counsel involved, and anything you send to the judge needs to be sent to opposing counsel as well. Now, when we talked about engaging in discovery and getting this evidence that you may need, the ultimate reason is, if you look at that first bullet point under the first indication there, it says the AJ is going to set dates and deadlines for discovery, and it says, and summary judgment. And summary judgment. So what is that? You, when you bring this case, have the burden of proof. I always kind of hunch my shoulders because it rests with you throughout the entire case. You've said it, so now you're being told, okay, prove your case. The idea of discovery is to give you the opportunity to rake in as much evidence as you can find so that you can say, okay, here, judge, here's my evidence. When you begin, way back when you make that complaint to the counselor and they take those issues and accept them, that is you alleging what has happened to you, alleging that it has happened because of your race, your sex, your age, your national origin, religion, your handicap, or in retaliation for EEO activity. Now, as you go through discovery, what you are doing is gathering the evidence to prove what you said when you started. Here are the things that happened to me for discriminatory reasons. Now the judge says, go discover the evidence that the law says you need to prove a race case, a gender case, disability case. So at the end of this process, it is not simply what you say happened to you. It's what you can prove happened to you. So it's a very important process because now the judge will no longer accept you saying, I didn't get training because of my gender. Now the judge is going to say, well, what evidence do you have of that? And during this discovery process, you get to ask the agency, identify all the people who were permitted to go to training. And what you're hoping to get back is a list that includes all males and not a female, because that's at least arguably evidence that you as a female was the only person that was left out. That starts the dialogue or the potential for, unless there's some other reason that the agency offers, it sort of stands that jury or judge could determine that unless there's some differences between these individuals, looks like it's maybe gender that kept this person out. So it gets a little complicated, but it's focused and it's specific, and navigating it certainly requires some help in most instances. But if and when you get that evidence, you're going to need to use it to defend that summary judgment motion. So the agency typically, you get to file it as the complainant as well, but that's very rare. But the agency will file a motion saying, okay, judge, when Ms. X started this case, she claimed these 5 things and said these things happened for discriminatory reasons. Now we're at the end of discovery. And that is the opportunity for us to stop and revisit the case. So we believe through this motion for summary judgment, Your Honor, that we're going to show that there is no evidence to support that these 5 things happened because of discrimination. You get to file an opposition. It's called an opposition to the motion for summary judgment. If you do not file your opposition, and if you do not file it timely, then the summary judgment motion will likely be considered conceded, and they could win by what we call default if the record doesn't support you enough. So important to oppose that motion, but more important for you to have evidence typically beyond the report of investigation, where you can say, okay, here's my evidence to show why it was gender. Here's my evidence for this reason. And so all of that becomes very important, and it ties it all together. If you do not have the evidence to rebut what it is that management is offering as what we call alleged legitimate, non-discriminatory reasons, you have a chance to say, no, that sounds good today, but that's not the true reason, or that reason is not worthy of credence, or it's even a lie. You got to come back to say that. And then the judge can decide, well, I need to have a hearing to figure out credibility, to assess the witnesses, to look at things from a different view. If you don't have the ability to challenge the legitimacy of a proposed or articulated reason, then your case fails as a matter of law, and the court will grant summary judgment, which means your case is dismissed. Okay? Now, you have the pre-hearing and hearing dates that are given, and these deadlines actually can change depending on what happens in discovery, but pre-hearing is for the purposes of looking at the issues that are going forward, because after summary judgment is granted, sometimes I have people who come and they say, well, these things happened and it was because of all of those things: race, sex, age, national origin, religion, handicap, and that's why it happened. And you sometimes want to say, well, let's focus on what you really have as your strongest point. And they're like, nope, I really think it's all of these things. So you move forward. When that summary judgment motion is filed, the agency is going to challenge each one of those bases and see whether you have the evidence for each one. What you need to prove age discrimination is going to be different than what you need to prove discrimination based on your religion. But you have to prove each one if you've checked that box and moved it forward. So the judge at the end of the day could make a decision on summary judgment that says, I'm going to keep this case in play. I'm not going to dismiss it entirely, but I will dismiss claims 1, 2, 3, and 4, because I don't believe that those claims occurred. Or the judge can say, I'm going to keep all of the claims, but I'm dismissing the bases of age, disability, national origin, religion, because I don't see any evidence of that. So you go forward with just maybe 2 bases. So that's how it could work. But by the time you get to the pre-hearing stage, which is that second bullet under the first divot there, you're basically saying to the judge, here's what I want to present as evidence for those claims and for those bases that have survived that summary judgment challenge. If the motion is granted in its entirety, the case is gone. But if anything is left, that's what happens at the pre-hearing. The judge says, okay, who will be the witnesses and what documents will you use as evidence when we have this hearing? And those witnesses and those documents are presented in advance before this hearing occurs, and the judge will either approve or deny your witnesses. So you may have a strong conviction about a witness who's going to be able to say that your supervisor was wrong, and your supervisor was wrong when they said you were not performing properly. Here's a colleague who knew what you were doing, who watched you every day, and the judge may say, nope, I'm not going to allow a colleague to talk about your performance because they're not a supervisor. They can't speak from that perspective. That witness is denied. And you go through until you have approved witnesses for both sides, agency and you, and then you have approved documents, and then a date is set for that hearing to happen. So as you can see, by the time you get to the actual hearing, you already know the witnesses and what they're going to say because they've been pre-approved. You already know the documents because they have also been pre-approved. So now, at this point, we talked about the motions practice where one side could claim, you haven't given me everything, I need more information if you're not answering those questions completely. Now you have the summary judgment. Now, we didn't talk about what could happen during discovery as it relates to depositions, okay? Depositions are when you bring someone forward into a room like this and you say, I want to ask you questions under oath. There's a court reporter there, agency counsel is there, you are there. And you can have your witness deposed, or you can depose one of your management officials. Now that process is an important process because it gets evidence, it gets information, and it also puts supervisors and other individuals in a hot seat, so to speak, to the point where they now have to answer exactly what you've been trying to find out all along. Why did I not get this position? Why did you, when I came to you, tell me one thing when now I'm reading in the record that you're claiming it's this? Didn't you say whatever? So you get to talk to them up to 7 hours. They get to talk to you, though, and depose you as well for that period of time. And depositions are used, as it indicates in that last bullet, as a method of discovery beyond that written discovery that I mentioned, where you write for interrogatories, requests for documents, or admissions. And you actually see as well that the responsible management official or witnesses can be deposed. That's an expensive process because once you finish, you have to purchase that transcript. And if multiple people are questioned, you can run up the dollars in terms of what it is. But that really doesn't matter if it's evidence and it's needed, and it can help you survive summary judgment. Next slide. Now, when we talk about the actual case, you actually have a judge where the judge who gets identified as the judge who's going to be handling your case, before they actually set this initial conference, before they actually do anything, you actually could have what's called a PCI. And that PCI, which is what we say is a way for the judge to get an idea of how well you feel about your record. That PCI is important because it's also there where you identify the information or the witnesses that you were not allowed to advance in that formal case when that investigator wouldn't allow you to do it. So I just wanted to go back for a second and talk about that. All right, so administrative judge's decision is issued. Now, you don't like the judge's decision, let's say. You've decided that that decision, I just don't believe the judge gave full consideration to arguments made, evidence presented, or circumstances that you pointed out. You have a right to appeal. So that is correct. It does not end with the judge's decision if it's against you. You have a deadline of 30 days after receiving that decision to note your appeal. So if you're making a written brief, that brief is going to be due to the Office of Federal Operations, and that's what the OFO stands for in this slide here. And you have to submit the request within that period of time. Then you have 30 days afterwards where you're going to have to file your brief. So you note the appeal by indicating, I intend to appeal this decision. 30 days later, you have a brief that's going to be due, and that brief has to be submitted. And another key thing that we have here is that the Office of Federal Operations will review the record. So here it comes. When you're going this process and you want to review, that particular review consists of what it was, the case materials that were part of your report of investigation. Let's just say you have an epiphany and you decide, you know, there are other things that I didn't think about through this process that's going to blow this case out of the waters. Do you want to go through the OFO process alone? Likely not then, because in that instance, you are not going to be able to add things to the record that were not there before unless you meet specific circumstances. So think about what you're trying to do and what you're leaning on when you take an appeal to the Office of Federal Operations. The process, as it states there, can be quite lengthy once you submit it and you go through that. It's better than how it used to be, but it does take a considerable amount of time to get through that process. Let's go to the next slide. So some people want to know, okay, I really don't want to do this anymore. I just want to go to court. And that's what our first divot there talks about. That says you may opt out of the EEO process and bring a lawsuit to district court. And so let's say you get that report of investigation that we talked about a while ago, and you say, I don't even want to do the administrative judge. Is there any way I can go to court right away? The answer is yes. So you'll have in your appeal rights the ability to jump over the EEOC process with the administrative judge and go directly into federal court. So what we have here kind of outlines what your options are. So you can do it after 180 days from the time that you filed your formal EEO complaint. So that again is jumping over that EEOC process. And if there has been no final agency decision issued and you did not file an appeal with the Office of Federal Operations, or you can do it within 90 days after you've received the final agency decision and you have not filed that OFO appeal that we talked about. Or again, after 180 days from the time you file the OFO appeal, if you've not had a decision. So if you remember a few minutes ago, I said it takes a while. So you're not stuck waiting. There are options that allow you to opt out once we call the exclusivity period ending. So there's an exclusive jurisdiction for the first time, for these periods of time. Once it's passed, for example, that second, the bullet from the bottom, after 180 days, if the decision, no decision has been issued. So the question I get sometimes is, do we have to sit and wait? Well, you get the ability to go on after that 180-day period if you've not gotten your decision, or within 90 days of receiving your OFO decision. So you have the right to do this at that particular point. That may be all confusing, what I just said. There are specific things that will go into why you will make a decision to sit and to wait. I talk about it all the time with clients. It will differ depending on your facts and circumstances, but this is what's available to you in the event. Now, next slide. So because we know that mistakes can happen at any time during the process, it is really best to consult an attorney to make all of your decisions and putting all of your evidence together so that you can make the best showing to prove that you were a victim of discrimination. Settlements actually can happen, as you heard me say, at any stage. Sometimes knowing what's valuable in terms of the agency's concerns and considerations will help us know how to bring them to the table to settle. And that's information that we have and that we can share with you about bringing your case to a point where settlement makes more sense. And it can happen and be revisited throughout this entire process. One of the things that I think is very critical in this whole process, talking about settlement and talking about getting the agency interested in considering settlement, is the reasons for why you want to settle and the reasons for why an agency may want to settle totally different. But it is very important, I hope you can see as we get to this stage, to have an attorney involved, probably even before you make that first approach to the counselor, because what you say and how you say it can make the difference. And I'll leave this one example. And there were times, many years ago, I actually was an investigator who went out and investigated these claims all over the country for Navy, for Army, for Marines. And I encountered someone at the Philadelphia Naval Shipyard. And she was adamant that she was being discriminated against. And she was also adamant that it was because she was an African-American woman. And as I took the information as the neutral, the uninvolved person simply gathering information for the report of investigation, it became very clear to me that there was some differential treatment likely going on, but it was related to her gender. This was a guy's shop. They didn't really appreciate women being there. They were giving her all the signs and symptoms of it, but she locked into it being because she was also the only African-American, and that's what she focused on. So it is sometimes helpful to have an attorney looking at the facts from a different perspective, because if you take that case just as she did, as a race case, you have to prove evidence for race discrimination. And in that instance, she did not have that. And back then, we used to write decisions and make findings. And my finding in that case was that there was no discrimination based on race. But if someone were to ask me, well, would you change that if you were looking at gender? I would have said yes. That's not what she advanced. I wasn't there to represent her. I was there to take her case and see if she has the evidence for what she said. How many times may you have you been in that position where you have it, but when you're asked to articulate it, you're not saying what you need to say? And that's when Tully Rinckey and what we do here and all of our offices can help you and assist you in bringing that case and oftentimes bringing it successfully. Next slide. So we actually provide assistance in these areas in writing the informal and formal complaints, making timely contact with the EEO counselors, representing you at mediations, and before these administrative judges, and also before federal judges. We do this. This is what we do. We do it well. Our record speaks for itself. And that We can actually go into federal court in the various jurisdictions that we have attorneys licensed, but we also have the ability to do affiliations to the extent that we can get local counsel to assist us as we move forward on cases that may end up in federal court. But in terms of being before the commission, we can do that in the states, and we've been doing it and doing it well for many people. And welcome the opportunity to help or assist you with your questions, with your case. In the next slide. When you actually contact an attorney and you're coming to talk with an attorney, to get the best and the most out of a consultation, you really want to be able to talk about what took place, when it took place, because as you have heard, dates and times will matter, especially depending on what you select as the discriminating bases for you. How often it took place becomes important. Who initiated the contact, the act? Who is the person that you are saying did this? And were there any witnesses? Because what I've come to find is people will tell me, oh, there are plenty of people who can, confirm this. And then what I later learned is that whomever it is they're advancing knows about it because what the client has told them. They don't have what we call personal knowledge. And that information sometimes will not be able to be advanced as supportive information because it's what we all know to be hearsay. And at this level, I'm happy to say, hearsay is sometimes accepted. And that is a difference between what happens in court versus what happens at an administrative agency. So you may have heard me say earlier that the decision as to where you should go and how you should do it will depend on your facts. If you have a lot of things that's going to be supported by hearsay, you may do better staying at the administrative level until your case, factors out. Because in court, federal court, it may not actually get to come out. Last thing I have on this page is that you should come with information to contact the EEO counselor. Phone number, name, of course, phone number, and email address, so we can help you in making that initiating contact as needed. Next slide. So, what we'd like you to remember, discrimination should never be tolerated, accepted. You should consult an attorney before filing any claim and provide complete timelines because the agency will be checking as to whether you met that initial 45-day deadline, whether you filed your formal complaint timely, and whether you responded and corrected any errors in how they identified your accepted claims. Remember your deadlines. I've seen wonderful and very strong claims just not be able to go forward because deadlines were missed. It's going to be a long battle, but the good news is that when we get involved as your counsel, the battle becomes ours. You're along there with us, but you do really get to allow us to take this on for you, move it forward. It's what we do. It's what we do daily, and we're happy to do that for you. Next slide. All right, so the impact of filing an amendment, as I stated earlier, does extend out the time. And so if you are going to agree to amend your complaint officially, it will extend the time out for when you have that window where you can pull it and move to the next stage. If you've done an amendment, you're going to have to give them more time, as we indicated, to complete the investigation in your case. So for the question of what should I expect during my interaction with the assigned EEO investigator, well, that investigator is there to basically ask you to prove what it is that you have asserted. So this investigator will navigate and control, first of all, what you get asked, because those questions will be designed either in writing or that investigator may want to call you and record the interview and or take down what your answers are as you're answering those questions on the call. That can be an hour, it could be 2 hours, really will depend on your claims and your bases. And so if the investigator decides that a particular witness or document is not helpful, they will make that call and likely not include it, but you can come back later and address that or challenge that. The investigator also will be speaking with management officials, getting those statements, and then presenting them to you for a rebuttal opportunity. And so that rebuttal opportunity gives you the chance to look at what management is saying in response to what it is you've alleged. and then having you explain or provide information to rebut that, to show it's not true, it's a lie, or it's not the full story of what happened. So are there limitations on rights for employees if they are in the probationary period on their job and subjected to discrimination? So when you are in a probationary period, typically your employer can let you go for any reason or no reason at all, if we're talking federal employees here. And so that creates a problem, because at that point, if you're thinking about filing an appeal, going to MSPB, that may be a problem for you. But if you believe that you were a victim of discrimination, your probationary status will not prevent you from making a discrimination complaint. So you will not have a problem in that regard. You can still make a complaint, even if you are a probationary employee, if you feel that you were subjected to unfair treatment. And I believe after summary judgment, that process has been answered. You can always appeal if you believe the judge got it wrong, and you can do that through filing something with the Office of Federal Operations, or you can go on to court. And what to expect during the discovery phase, as we already said, you're going to have the documents served on you. You have to answer within 30 days. Those questions, typically you can get up to 25 requests for admissions, requests for the production of documents, and interrogatory questions that you have to answer. And what you can expect is that agency is going to want those questions answered. And if you shortcut them or fail to answer them, they can serve you a notice saying that you have now failed to answer, so your responses are deficient. And in that instance, they can get the judge involved through what's called a motion to compel. If you fail to answer, the judge could get involved and order you or sanction you for failing to answer the questions. So this last part says positives and negatives of asking the judge to make a decision with the evidence presented. I assume that you're saying on the record from the report of investigation, if you're talking about getting a decision on the record through a FAD, it depends on how strongly you feel about this record. If you feel that the investigator didn't add certain documents or didn't speak to certain witnesses, you may not want that. And so you have to make that decision. I have a couple of questions here. One is saying, would more time be provided if the investigator failed to move the process along to attempt to resolve it? So when you say more time, you can always agree to an extension of time if there are more things that need to be done in order for the investigation to occur. So I assume that's what you're speaking about. And what can or should happen to agency witnesses when they lie or their statement via an affidavit? Well, I have my own theory about that. I mean, that's a question that I always struggle with, because when we bring these cases, and I am examining a responsible management official, and I'm able to impeach that person, which is to show that they're not speaking truthfully or there's something deceptive about what they've stated, I often wonder, I mean, at the time that it's happening, there isn't anything the judge will do. And so it essentially is going to be left up to the agency to take the proper action in terms of what they want to do. And so those are the questions that I was able to get to at this point. Thank you for joining us. Taylor, is there anything else that you need from me at this time?
No, we're all set. Thank you everyone for joining today's presentation, and thank you, Donna, for presenting. Yes. This presentation was recorded and a copy will be sent to all attendees in the next couple days. I hope everyone has a good rest of their day.